If your spouse won't comply with the orders of the court, go to your attorney and file a petition for contempt. Please don't try to do that yourself. Representing yourself in even as basic a matter as contempt makes as much sense as going to the hospital and wanting to be your own surgeon. One of the saddest pro bono cases we ever took on was a young lady whose ex-spouse was continuing to show up and abuse her, and the pleadings she had filed were so bad there was nothing the court could do for her. There are basically two types of contempt, and contempt is what the court holds somebody in who doesn't follow their orders. So it can be civil or criminal. Civil is you violated the court's order, you had the ability to comply, but you chose not to do so, and the court can put you in jail until you comply. That's a great situation for a spouse who refuses to sign over a deed on transferring property they've been ordered to transfer. The other is criminal contempt, and this is something you can't go back and fix. You don't have the ability to get yourself out of jail by doing the right thing. In criminal contempt, and one of the classic examples of it is one spouse not giving the other spouse their visitation when they're supposed to have it. The court can't put you in jail for you to make that time up. But what the court can do, and in Tennessee, it's 10 days. They can put you in jail for 10 days for each violation. Now, in criminal contempt, you get the rights of a criminally accused. It's also a slower process. So if you can do civil, you want to do civil. If you have to do criminal, you do criminal, but make sure you have a law firm that understands the ins and outs of civil and criminal contempt when you're in danger of losing your rights.